Basic Appraisal Principles, page 214. Creditor, called the beneficiary, and an independent third party, often an attorney or title insurance company, called the trustee. The deed of trust is not used in all states. Transfer after death. A deed transfers title to property only if the grantor is alive. A deed cannot be delivered by a dead grantor. Even so, property can be transferred after the owner's death. Property that someone inherits by will is often sold rather than kept for personal use. See Table 9-9.2. It is therefore helpful for appraisers of real estate to have a general understanding of how property is inherited or acquired by will. Let's begin by reviewing definitions. Probate. Probate is the process by which legal title to property is transferred from a deceased person's estate to the beneficiaries. Devise. Devise is the act of transferring deceased devisors' interests in real estate to another interest, the devisee. Testate. Testate is the circumstance of dying, having made a valid will. Someone who dies and leaves behind a will is said to have died testate. Intestate. Intestate is the circumstance of dying without a valid will. Someone who dies and did not leave behind a will is said to have died intestate. Testate. A person who dies and leaves behind a valid will is said to have died testate. This simply means that there is a testament, which means a will, that states how the deceased person wants property to be distributed. Some special terminology is used in reference to wills. A person who makes out a will is called the testator. A testator bequeaths personal property to legatees and devises real property to devisees. An amendment to a will is called a codicil. An executor is someone the testator names in the will to carry out the instructions in the will under the supervision of the probate court. If an executor is not named in the will, the court will appoint an administrator to carry out the instructions in the will. Probate is the legal process by which a deceased person's assets are distributed. Laws and requirements regarding wills vary by state. Table 9.2, will terminology. The term testator, definition, one who makes a will. The term bequeath, bequeath, its definition is to transfer personal property by will. The term devise, definition, to transfer real property by will. The term codicil, codicil, definition, it's an amendment to a will. The term executor or administrator definition, carries out instructions in the will or from the probate court. And lastly, the term probate definition. It's the legal procedure for distributing a deceased person's assets. Page 215. Intestate. A person who dies without leaving a will is said to have died intestate. The law provides for the distribution of an intestate owner's property by a process called intestate succession. Each state has its own rules of intestate succession, likely found under probate code. The following is an example of how intestate succession might look. Be advised that all states will have their own laws regarding this subject. The following is provided as an example to understand the concept of intestate. Sample intestate succession. Number 1. If there is a surviving spouse, the surviving spouse receives the entire estate. Number 2. There is an exception to that rule if one or more of the deceased person's surviving descendants, whether children or grandchildren, are not the descendants of the surviving spouse, or if the surviving spouse has one or more surviving descendants who are not the descendants of the deceased. In either of those cases, the surviving spouse receives the first $150,000 from the estate, plus half of any remaining balance. The other half is shared among the deceased person's surviving descendants. For example, when Colleen Haskell died intestate, she was survived by her husband, Bill, and their 2 children, Jeanne and Rob. Under the rules of intestate succession, Bill, the surviving spouse, inherits his wife's entire estate. Now, suppose instead that Jeanne and Rob were Colleen's children from a previous marriage, rather than the children of Colleen and Bill. In that case, the surviving spouse, Bill, is entitled to the first $150,000 of the estate, plus half of the remaining balance. The deceased person's surviving descendants, Jeanne and Rob, share the other half of the remaining balance of their mother's estate. In other words, Jeanne and Rob each receive 1/4 of the remaining balance. Number 3. These general rules concerning inheritance by a surviving spouse are subject to the rules concerning the elective share described in the following section. Number 3 continued. If there are surviving children, but no surviving spouse, the children share equally. Note that if a child has died before the parent, but there are grandchildren, the grandchildren take the parent's share. For example, when Alan Cole died intestate, he was survived by his son, Ben, and by 3 grandchildren. David, who is Ben's child, Emily and Francis. Emily and Francis are the children of Alan's daughter, Carol, who was killed in a car accident several years earlier. Half of Alan Cole's estate goes to his son, Ben. The other half, which would have gone to Alan's daughter, Carol, if she were still alive, is shared by Carol's children, Emily and Francis. The third grandchild, David, is not entitled to a share of the estate because his parent, Ben, is still alive.